Good evening and welcome back to Counselor's Corner. I'm Mark Simon with Simon & Berman. The topic today is going to be shareholder buy-sell agreements. Typically, when a corporation is initially organized, it is most common to simply elect directors and officers and issue stock to those persons that actually fund and thus own the business. However, what is all too often not addressed is the preparation of a shareholder buy-sell agreement. This type of an agreement, which you must understand is totally distinct from corporate bylaws, the rules and regulations of a company, must and should be prepared well prior to it ever being needed. It also should address, at a minimum, the following types of things. Number one, what stock transfers a shareholder should be permitted to make. For example, can they transfer shares to their living trust without having to first offer shares of stock to the other shareholders or the corporation? Number two, before the sale of your shares to an outside third party, do the other stockholders have rights of first refusal? Number three, what happens to the shares of a stockholder who gets divorced? Is their spouse required to surrender their shares of stock to the company? And if so, upon what terms? Number four, what if a shareholder dies? Must the estate of the deceased shareholder give up the shares? And again, if so, upon what terms? What happens if a shareholder becomes mentally or physically disabled or incapacitated? Is a corporation going to be required to carry disability or life insurance for the benefit of a shareholder? And if it does, can the insurance be utilized by the corporation to buy the shares of stock from the disabled shareholder or the deceased person's estate? How is the purchase price for the shares going to be determined? Further, does the price have to all be paid in full, or can it be possible to give a note for a down payment and pay the rest in installments? And what happens if a shareholder violates the terms of the buy-sell agreement? What are the rights of the other stockholders? These are only some of many questions and problems that may result and can be resolved by a well-drafted shareholder buy-sell agreement. Please call us to discuss these matters further, and thank you again for joining me on Counselor's Corner.